It's now my pleasure to introduce Alexandra Faraguna from the Intellectual Disability Rights Service in New South Wales. Alex was also a person that Nagadeva commandeered after attending the Wollongong Symposium on criminal justice and people who are marginalised. And thank you for sharing your...
Okay, well, thank you very much for being here, and I'd like to thank the organisers of the symposium for offering me the very exciting opportunity to speak and to listen to the other speakers. I think it's quite appropriate that I'm speaking after Leanne because all the UNSW research certainly mirrors what we see happening every day, sort of on the ground. So my name is Alex Faraguna and I'm from the Intellectual Disability Rights Service, or IDRS, which is a specialist not-for-profit community legal centre in Sydney that works for and with people with intellectual disability across New South Wales. We have a team of solicitors who provide advice and limited representation for issues concerning our clients with intellectual disability, and they often include complaints about disability services, fines, debts, questions around wills and estates, discrimination, consumer problems, guardianship and financial management. And that last one, financial management problems, is a very common legal advice that we do. IDRS also has a pilot project that provides legal assistance for parents with intellectual disability who are at risk of having their children removed by community services. Okay. So the program that I manage at IDRS is called the Criminal Justice Support Network, or CJSN, and we provide support for defendants, witnesses and victims of crime with intellectual disability, mainly at police stations and courts, but also in alternate dispute resolution as well. 90% of our clients are defendants, and many of these are appearing in a local court charged with a relatively minor but often repeated offences. Offence types are varied. We have a few clients charged with very serious offences along the lines of murder and manslaughter, but obviously they're certainly not in the majority. The most common types of offence that our clients are charged with are listed on this slide. And many of our clients have very lengthy criminal histories stretching back to sort of around about their teenage years. Many have complex needs, including mental health problems, problematic drug and alcohol use, homelessness, and some come from families where violence and criminal charges are common, or people were institutionalised as children and have long histories of severe abuse, trauma and neglect. Some of our clients are from the generation where the parents were told to put them in an institution and forget about them. Not the younger ones, but the clients sort of in their 30s, 40s and upwards. The Equal Before the Law report was published this year by the Australian Human Rights Commission, and CJSN contributed to that as well. Disability Discrimination Commissioner Graham Innes-AM notes at the beginning of the report that equality is not always available for Australians with disabilities in the criminal justice system, which sounds a bit of an understatement after listening to Leanne's presentation. Equal Before the Law provides many examples and case studies where the law has failed people with disabilities and compounded disadvantage. As the report says, whether a person with disability is the victim of a crime, accused of a crime or a witness, they are at increased risk of being disrespected and disbelieved and not enjoying equality before the law. I didn't know that was going to happen, that fade in. Okay. So in our experience, people with intellectual disability are disproportionately cast into the role of criminal, whilst their vulnerability to victimisation is poorly understood and addressed. And I think Leanne gave a really good explanation of why that is. Challenging behaviours are frequently criminalised when the person lacks capacity or support to behave in more appropriate ways. Police often struggle to believe a victim's story, which is sometimes because the person finds it difficult to provide clear timelines and versions of events. When the person is an alleged offender, however, incriminating information and admissions suddenly appear very credible to police. The criminal justice system fails to understand the complex causes of offending for this group and interprets behaviour as deliberately unlawful rather than recognising the impact of unmet support needs. Behaviours and characteristics associated with a person's disability can be perceived by police as indicators of untruthfulness or deceit rather than being part of the person's disability. And that would include things like the client's appearance, reluctance to make eye contact, delayed responses to questions, anxiety, slurred speech, or unusual behaviours that are often quickly interpreted as criminal. And just, I suppose it's also good to note that a person's appearance is really important to police as well. I've had many times in police stations when I've been there as a support person, the police will say to me, "Oh, do they really have a disability?" or "They don't have a disability, they look normal." And so I do notice that if somebody has some kind of physical characteristic that marks them out as having a disability, police tend to believe them more and to be a little bit more compassionate towards them. The Equal Before the Law report conducted a countrywide consultation in the past year to assess how people with disabilities are affected by the following 5 identified barriers to justice. And they are the community support programs and assistance to prevent violence and disadvantage and address a range of health and social risk factors may not be available to some people with disabilities, particularly in regional and remote areas. We are funded to be a statewide service, but obviously our funding is not very high. It's probably the same as everyone else here. So we can't actually have on-the-ground services in all areas of New South Wales. So some people have to rely on support and information by telephone, which is better than nothing, but certainly not ideal. People with disabilities do not receive the support, adjustments or aids that they need to access protections, to begin or defend criminal matters, or to participate in the criminal justice processes in a meaningful sense. Negative attitudes and assumptions about people with disabilities often result in the person being viewed as unreliable, not credible, or not capable of giving evidence, making legal decisions, or participating in legal proceedings. Specialist support, accommodation and programs may not be provided to people with disabilities when they are considered unable to understand or respond to the criminal charges made against them, or in other words, unfit to plead. A strong example of programs that our clients are usually just found not suitable for as soon as they really approach them is the MERIT program, the Magistrates Early Referral into Treatment, which is a drug and alcohol program in New South Wales. Our clients are often just turned away very, very quickly because of the written aspects of it and the cognitive behavioural sort of aspects of it. Support, adjustments and aids may not be provided to prisoners with disabilities so that they can meet basic human needs and participate in prison life. We do have a fair number of clients who are in custody from time to time, and we're able to send support persons into the jails to assist them from there. And so these are the barriers that IDRS and CJSN see happening in practice sort of every day. It appears to us that the criminal justice system is much more willing to recognise criminality in people with intellectual disability rather than to recognise victimhood. And I'd like to discuss 2 areas where this bias is very obvious to us in our experience. The first one being sexual assault. Researchers, including Susan Hayes at Sydney University, Moira Commody from the University of Western Sydney, Sue Ellen Murray from the Royal Melbourne Institute of Technology, and Anastasia Powell from La Trobe University, are some of the major researchers who confirm our experience that both men and women with intellectual disability are highly likely to be sexually assaulted at some stages of their lives. And the studies indicate that up to 90% of Australian women with an intellectual disability have been subjected to sexual abuse, more than 2/3 of them before they turned 18 years of age. I think what we find in practice is that our male clients seem to have been affected almost to the same degree. Despite extensive documentation and research into these horrifying statistics, it's not well recognised or addressed by the legal system, and it's a rare thing for a CJSN client to access justice through the courts. I can count on the fingers of less than one hand the number of clients who are victims of sexual assault that we've assisted who have actually got as far as the offender being convicted. IDRS's legal team has often had occasion to follow up with the police who fail to fully investigate alleged sexual assaults of our clients. Many cases fail at an early stage, and the conviction of a person for the sexual assault of one of our clients is exceedingly rare. A recent example of this is of a female client, I think in her 50s, and she's got some quite slurred speech and slowed responses, and I think some physical sort of disabilities as well. And that often led the police to assume that she was drunk when she tried to report breaches of an AVO against the man who had sexually assaulted her. And this happened despite us talking to the police station about the situation, and they agreed to flag her disability on their computer system. They did that, but it didn't really have much effect. Individual police officers either didn't look up the system, or they just ignored it, or didn't really understand the implications of her disability. Victims of sexual assault who have intellectual disability are often viewed by police or lawyers as unreliable witnesses, or unable to make a statement or to give evidence in court. And sometimes paternalistic attitudes lead decision makers to assume that subjecting a person with intellectual disability to court proceedings would be overwhelming for them. And, I mean, obviously, court proceedings are overwhelming for any victim of sexual assault, but we disagree. Many people with intellectual disability are able to act as competent witnesses when they are provided with appropriate support and court preparation. A blanket assumption to the contrary means that cases do not go ahead and perpetrators remain at liberty to sexually assault further victims. Many clients who receive services from CJSN as defendants disclose during casual conversation that they've been sexually assaulted in the past, often on multiple occasions and by different perpetrators. A number of those victims go on to become offenders themselves. The reasons are not quite clear, perhaps acting out their own past sexual abuse, or maybe so desensitised to such abuse that they will struggle to form any real understanding of its criminality. Effective and consistent measures by disability services, police and courts to protect people with intellectual disability from sexual assault could possibly help to prevent much suffering and some subsequent offences. So the Intellectual Disability Rights Service and Criminal Justice Support Network provides support to a significant number of clients who are accused of offences as well, such as sexual or indecent assault or the possession or dissemination of child abuse images. And the factors influencing such offences are likely to relate to the person's disability. Many clients have not had access to sex education and are uncertain about what behaviours are unacceptable and which are not. We often assist clients charged with aggravated sexual assault, with the circumstance of aggravation being the young age of the victim. And that is sometimes the result of a young man with an intellectual disability having a sexual relationship with a partner below the age of consent. That type of sexual assault can often lead to serious consequences such as jail, an outcome that's obviously seriously detrimental to people's physical and social well-being, disrupting houses, disrupting support services, and very often leaving the person in a much worse situation than they were in before they went into custody. It seems to us that there's a convenient stereotype to fit whichever side of a sexual assault matter our client falls on. Defendants might be viewed as hypersexual, unable to control their urges and in need of being controlled, rather than educated and supported and provided with services. Some parents and service providers still believe that information and education about sexuality will encourage inappropriate sexual behaviour, with the assumption that any form of sexuality is inappropriate for a person with intellectual disability. And that is something that we very often see with clients' parents, is that they just really don't want to go there. Victims, on the other hand, sometimes can be seen as asexual or an eternal child rather than a fully functioning adult that they are, and sometimes as a person upon whom sexual assault has less impact than a victim without a disability. CJSN regularly comes across disability support services with poor or non-existent policies and procedures on the action to be taken when a client discloses sexual assault. A recent instance of this saw a woman disclose to a disability worker one morning that a staff member on the previous night shift in her group home had sexually assaulted her. The woman was showered, possibly destroying any forensic evidence, and sent off to her regular day programme as usual. There was no compassionate response involving counselling, emotional support, or a visit to the sexual assault service. It seemed like it was just business as usual. Luckily, they did call us though, so that was the one good thing that service did. So IDRS and CJSN's reform agenda includes sex education and resources for clients and disability sector workers, as well as the development of policies based on best practice. I'm sort of assuming something might slide into view there. But, oh, there we go. Yeah, this slide doesn't really relate to what I'm saying, but I think it sort of not directly to what I'm saying, but I think it does demonstrate sort of the dynamic between the police officer and the person in custody with intellectual disability. One of the other core areas of law that highlights the unsatisfactory responses to people as alleged offenders and victims is apprehended violence orders, or AVO proceedings, which I think are called other names in other states, such as intervention, restraint or protection orders. Apprehended domestic violence orders, or ADVOs, relate to family violence in New South Wales, and apprehended personal violence orders, or APVOs, relate to non-family violence. Although AVO proceedings are not a criminal matter per se, a breach of an AVO order carries potentially serious criminal sanctions, including up to 2 years' imprisonment. It's our experience that police often disproportionately target people with intellectual disability as defendants in AVO proceedings, whilst victims of violence are rarely able to receive adequate protection through the law and criminal justice system. It's our experience that complaints concerning violence towards people with intellectual disability are often not taken seriously. Their accounts are discredited by police, court processes are onerous, and free legal representation is becoming more and more rare. New South Wales Legal Aid does not provide legal representation for people who need to apply for an apprehended personal violence order, meaning that applicants need to be able to advocate for themselves in court, perhaps against a defendant who has a lawyer to represent them, which is an obviously very uneven playing field that leaves people with intellectual disability vulnerable to harassment and threats from neighbours and other non-related people. Many of our clients, as a consequence, live in environments where violence is frequent and court appearances are a regular part of their lives. Currently, IDRS is particularly focusing on AVO proceedings where the defendant does not have the capacity to understand an order, and we're about to organise a workshop on that with our recently written paper. In most jurisdictions, fitness to plead or fitness to stand trial in the context of summary offences is an issue that has been rather neglected or given little attention. Only in South Australia, Tasmania, Western Australia and the ACT allow magistrates to deal specifically with the issue of an accused's fitness. Victoria, Queensland and the Northern Territory do not have legislation dealing with this issue in the context of summary offences. And as the legislation currently stands in New South Wales, there is minimal provision to take into account a defendant's understanding of the proceedings. People with intellectual disability who breach AVOs may be encouraged by solicitors to simply plead guilty, although they may be unfit to do so. In New South Wales, incapacity in the local court is a very largely untested area. AVO proceedings are particularly problematic for people with intellectual disability as defendants because they are often not able to understand such orders and often don't have the appropriate supports to assist them in complying with the orders. Alternate or emergency accommodation is rarely available for our clients who often have complex needs and multiple diagnoses. The risks to defendants as a consequence of AVOs are not always foreshadowed by legal representatives, when a person does in fact have representation at all. And people with intellectual disability are often encouraged to simply consent to the AVO order. And our clients might focus more on short-term gain than their best interest in the long term, and might quite often readily agree to this in order to get it over with and to end what for them is a very stressful situation. Legal Aid in New South Wales is often unwilling to provide representation for defended AVO hearings anymore, demonstrating a lack of understanding of the dangers of accepting an AVO and the likelihood of breaching the conditions. For people with disabilities who have complex needs, there is an ever-present risk that in the absence of support they will give inconsistent evidence or plead guilty just to get the process over with. From our observations, it appears that AVOs against defendants with intellectual disability all too often serve as a gateway into the criminal justice system, creating a high risk of imprisonment due to breaching. One of the most concerning issues is that from our observation, AVOs appear to be used as a method of behaviour intervention for clients with complex needs or challenging behaviour, particularly within group homes, where there might be a lack of appropriate social services supports or adequately trained or available staff. AVOs also appear to be used by service providers in order to break a stalemate of inappropriate housing because they feel that there's no alternative. We've certainly had staff members taking out AVOs against clients because they want the client exited from their service because they're just too difficult. Although diversionary options such as Section 32 of the New South Wales Mental Health Criminal Procedures Act 1990 may be available to defendants charged with breaches under AVO legislation, but Section 32 orders are discretionary. And they're also underutilised by the courts, and there are often practical hurdles, such as obtaining treatment plans and court supports, which mean that the availability of Section 32 is not a sufficient measure to remedy the problems associated with AVOs made where the person has little or no chance of complying with them. Even where a charge may eventually be dismissed, many clients end up serving periods in custody on remand whilst they wait for their matters to be finalised. In our experience, this often has devastating consequences for particularly vulnerable defendants, often exposing them to exploitation and abuse in custody. In the last month or so, the bail laws in New South Wales have just changed, so, and I think it's actually a little bit of an improvement, so we're hoping that we might have fewer clients on remand. Okay, so I just have a couple of case studies to share, and they're both in relation to AVO proceedings. The first case study is that of Jessica. Now, Jessica was a 23-year-old woman who lived in a group home, and she's been diagnosed with mild to moderate intellectual disability. Jessica had a long history of childhood neglect and physical and sexual abuse that had only recently been acknowledged as a major factor behind her challenging behaviour and development of chronic post-traumatic stress disorder. Jessica's complex history of trauma meant that she found it very difficult to form relationships, particularly with staff members and other clients living in the group home. There was one particular resident who Jessica particularly did not get along with and would continually harass Jessica so that she would become upset and angry. Although she had only been living in the group home for a few months, Jessica had several AVOs taken out against her by several staff members in the group home, as well as the other resident. Jessica herself was also the protected person in another AVO. This particular incident arose as Jessica became upset when she felt the particular staff member was spending too much time with the other resident in the group home. She allegedly began to yell and used her body to block the staff member from exiting the room. The police were called and determined that the situation was a domestic violence-related offence. The police charged Jessica with common assault and also charged her for breaching the AVO, which was issued a few days earlier as a result of a similar incident. The staff member indicated that she wanted to take out an AVO because she thought this would help persuade the Disability Service to find alternative accommodation for Jessica. The second case study is that of Matthew, and he was 39 years old and resided in a supported accommodation unit when he came to us for assistance. Psychological assessments indicated that Matthew had an IQ of around 47, where his most profound deficits were in relation to communication, and he also had no family support. As a result of his disability, Matthew had been provided with almost no sex education at all and had very little understanding about relationships with women. Approximately 4 years prior, he had formed a relationship with a female neighbour who was also lonely and looking for friendship. Unfortunately, shortly after meeting, their friendship turned sour, resulting in criminal charges and a provisional apprehended personal violence order, which was taken out by the police against Matthew. It was alleged that Matthew would follow the woman and ask her why she did not want to be friends with him. He didn't understand the AVO order and believed that he and the neighbour were boyfriend and girlfriend. As Matthew did not understand what the AVO meant, he continued to approach the neighbour in the street and get upset and yell at her when she refused to talk to him further. Matthew's attempts to continue to talk to the woman meant that the police were called and Matthew was arrested and refused bail. When he appeared before the local court in relation to bail, the magistrate refused to grant it because Matthew lived too close to the protected person and had nowhere else to live. Matthew was sent to prison, where he remained for over 4 months on remand. When we visited Matthew in custody, we found him very disoriented and confused, his shirt blood-stained. He didn't know why he was in prison and said he had not been able to shower properly or brush his teeth. Matthew usually needed staff to help him with those tasks. He remained in custody for a further 2 months until alternative accommodation was eventually found by his disability service provider. So, in terms of what we do about all this, this is a still from CJSN's Train the Trainer kit, which enables disability service staff to teach their clients what to do if they're arrested. This kit is available free of charge on our website. We provide free telephone legal advice to people who've been arrested, and also a support person goes to the police station. Our solicitors provide legal advice to clients in plain language, avoiding legal jargon, or at least explaining it when it's unavoidable, checking understanding, getting the person to repeat back what they've understood, and addressing misunderstandings, that sort of thing. Very common sense, plain language interventions that I'm sure everyone here is familiar with, but police really aren't. The legal advice is often not to consent to be interviewed or try to tell the police what happened, because there's a very great risk of the person being confused by the questions and what they say being misinterpreted and taken on face value, basically. The solicitor also advises police not to record on tape the person's refusal to be interviewed, because once the person gets into the video recording room, it's very difficult for them to remain silent, as is their right. The solicitor will also, if necessary, try to prevent forensic procedures such as DNA sampling from being carried out, as the person is very unlikely to have the capacity to fully understand the legal implications of this, and it is preferable that a magistrate make inquiries into whether or not this should happen. The solicitor can also help to advocate for the person to be granted bail with reasonable and achievable bail conditions that do not set the person up for failure and further charges of breaching bail. There have been occasions when I've been the support person at the police station, we've had a really good custody manager, and they've pretty much let me sort of say what the bail conditions should be. So that's a fantastic scenario, but that doesn't happen very often. So the service that we provide for people who've been arrested goes up until 10 o'clock at night, and we can obtain legal advice up until that time through a network of volunteer solicitors. Whenever possible, we send a support person who is very often a trained volunteer to the police station to help the client in various ways. And we help the client to understand their legal rights and ensure as far as possible that their rights are upheld by police. That is a real challenge. We educate police custody managers on a monthly basis about people's rights, or the rights of vulnerable persons in custody. Not every custody manager has done that training, and some who have done that training really don't seem to listen very much, which we can tell by the way that they refer people to us. If the client does agree to be interviewed, which is ultimately their choice, we try to ensure that the interview is conducted fairly, that the client understands questions and is not simply agreeing to whatever is put to them. Excessive acquiescence can be a real issue when the client tries to give the answer that they think the police officer wants to hear. And I noticed that our clients are very vulnerable to atmospheres as well as words. People, I think, who are less verbal are very sort of conscious of body language, and so they can really tell what they think the right answer they think is. We help clients to obtain, understand and remember their legal advice. The client might be absolutely fine on the phone with the solicitor, but 10 minutes later they might have forgotten the legal advice, or they just find it a very difficult thing to say no to somebody in authority and say no to a police officer. And sometimes we have to do quite a bit of troubleshooting and make sure that people understand, no, it's your right to say no to an interview. The police are not going to be upset with you, it's not going to be worse for you. We help the client to remain calm and avoid challenging behaviour that could lead to further charges. And I think the fact that we help the client to stay calm in custody is the main reason that the police actually do call us, is because they have a much easier time of it sometimes when we're there sort of almost babysitting the client for them. We help the client to understand and remember the conditions associated with their release, such as AVO and bail conditions, to decrease the chance of breaches and subsequent further charges. And in the case of victims of crime, because we also assist victims of crime to make reports to the police, we provide emotional support and again help the police to frame questions clearly and in plain language and without double-barrelled questions and all those communication barriers that are frequent. When the client attends legal advice appointments and court, the support person accompanies them in order to help the person to communicate effectively with their solicitor and to be able to tell their version of events and to instruct their solicitor. We help them to understand and remember the legal advice that they've got. We help them to prepare for an application to divert charges under Section 32 of the Mental Health Criminal Procedures Act. And that usually involves assessment by a psychologist to confirm intellectual disability and the formation of a treatment or case plan to address offending behaviour. And again, we help the person to remain calm and stay at court as long as they're needed to be there. As people might know, you can be sitting all day long in the local court, and it's a very tough ask for a person with intellectual disability to be able to stay calm and stay present for the whole day. There's just some general sort of references as well. In conclusion, we sort of see every day that people with intellectual disability continue to be overrepresented as defendants and under-recognised as victims of crime. Complex needs, including status as both a victim and offender, are under-recognised, and the impact on the life of the person is also very much underappreciated. Many of our clients live in disadvantaged communities where violence, AVOs and court appearances have been a regular part of their life for really quite some time. And many of our clients appear in court on a regular basis, often on very similar charges. There's very little appropriate help available to help break the cycle, and instead people with intellectual disability remain entrenched in the criminal justice system. And as Leanne mentioned, we also find that many of our clients have never really had any sort of disability services until they've been in custody and they've been referred that way. So, I mean, we're only a very small community legal centre. We have about 20 staff and most of them are part-time. And we do our best, but we certainly don't have enough funding to provide assistance to everyone who needs it. Our support statistics have just go up year upon year upon year, and our funding doesn't. What is common for all people with disabilities is the requirement for ready access to support when involved in criminal matters, which would ensure that people with disabilities are heard and their experiences are understood, and appropriate action can then result. And unfortunately, I think we're the only specialist service in New South Wales for defendants with intellectual disability. So, unfortunately, we can't meet the entire need. So that's sort of everything I wanted to say. So if anyone has any questions, or if anyone thinks of any questions after today, you'd be more than welcome to contact me, and I'd be very happy to have a chat with you as well. But I don't know if anyone has any questions at the moment.
What's your website for that change?
Oh, it's www.idrs.org.au, and it's called the Getting Arrested Kit. And there's a few other interesting packages and resources on there that people might be interested in too.
Where do you get most of your referrals from? From the police, from alt-right?
Disability service providers, really. Not that many at all from police. I mean, we do this many court supports and that many police supports. The police are really quite shocking at referring to us, and that's a problem with recognition of intellectual disability for them. It's actually quite a hard ask for us to expect police officers to sort of on the spot diagnose intellectual disability. So it's often disability service providers or families or carers, or sometimes the client themselves will give clients wallet cards once they've been in touch with us, so that they have a card with our number on it and that they can hand to a police officer if they are arrested, and hopefully the police will call us. Solicitors sometimes make referrals, juvenile justice, anyone, absolutely anybody is welcome to make a referral to us with the client's permission. Yeah.
Thank you. Thank you, women.
Okay.
Thank you.
Thank you.